Okay. Okay, good afternoon, ladies and gentlemen. Have your attention, please. All quiet, please. Thank you. All right. Go ahead, turn to your notes. We're going to continue looking at civil rights. Okay? We're right thick in the middle of criminal justice rights. Okay? Criminal justice rights. So there's a very, very important ones that are heavily represented in the Bill of Rights, as well as very important case law. Okay? In looking at kind of the big picture, I do have it written up here. Since we're not doing any particular tests, or quizzes, I should say, on sections of the actually, we've already done all the quizzes. You've done 4 of them on this unit. If you can go ahead and return your textbooks in, so that way I won't have to remind you, except for like on the very last day, when you guys are in here, your last exam in here is going to be on Monday, the 7th, so less than 2 weeks from today. We'll be having an exam, and I need to get the textbook from you. Otherwise, if you haven't turned it in by then, otherwise we'll get you a fine notice. It shouldn't be very fine for you, so just remember you can bring that in. I don't imagine there's going to be too much relative to this particular test, although you can hang on to it until the very last day if you think that it will help you. But the test is going to be based on what we're covering in class. Having said that, oh my gosh, we're just like, we just haven't had enough time together this year. We just haven't. Okay? I mean, that's just the way it is. So we haven't been able to cover as much. So we're going to be finishing up the civil rights unit. And then there's actually some additional material. And I'm like, are we going to get that in before the test? Are we going to do it at maybe a little unit at the beginning of next year? You know? So we'll see how today goes. But we might have a little bit of an additional material on politics, which I will include. And then we'll throw some questions in there on the test. But the test is going to be mostly, the vast majority is going to be the civil rights stuff, okay? Because basically we've got today, we've got Thursday, although it's going to be slightly shorter because of the assembly in the latter part of the day. We've got next Tuesday, and then next Thursday we finish up and we review, because the next time you guys come in here, we take the test, and then bye-bye, okay? All right, you guys, your next A day that you come here will be just first and second periods, and that'll be on Wednesday. Okay, does that make sense? Wednesday, because the last week of school, everything's a little different. Yeah. So next week, you don't have Monday. This week, you didn't have Monday. The following week, oh my gosh, it's the first and only time you go to school on Monday. Okay, are you ready for that? Yeah. No, I don't. One student is finishing up an ISAT. Otherwise, that's it, I think. Just the one. Yeah? Okay?
Ken, are you okay?
Okay. Those are not for you. Everybody keeps asking. I'm like, I should hide them somewhere. Mrs. Hawkins brought him in. It was a gift from her. She asked me to do a favor. I'm going to have to guard those hot tamales. No! Get back! Get back! You have a right to remain in your seat. What? Here we go. Write it down. Ernest Miranda. Ernesto Miranda. Okay? All right. The right to be informed. Do you have a right to be informed? You have an obligation to be informed before you come into my class, certainly for a test. If you're going to be going out in the public, on this, the anniversary, because I was reading the news, the anniversary of the arrest of Mr. Floyd in Minneapolis.
That was a year ago?
Which didn't end very well. Okay. One person dead, another person convicted. Okay, that was a year ago. Yeah, because I was checking on that. That was in the news today. You need to know responsibilities. Okay, so write this down. You ready? Police have to know about Miranda rights. The Miranda case has been with us since 1966. This is an expansion of the civil rights of people who are arrested or detained by the police. Okay? This is going to be one of a number of things that we've been talking about where the Supreme Court looks at the Constitution and goes, we're going to need to expand or tease out what is officially written in the Constitution in order to get what the Supreme Court says is more fairness for those involved. Okay? So, speaking of the Miranda decision, this is Ernesto Miranda, and I can't remember exactly what he was arrested for, but he was arrested for something, a serious crime. Okay? Actually, it was interesting because it was in the state of Arizona, because that's where that criminal charge was ultimately brought. And I remember years ago there was a local news media who was covering the anniversary of the Miranda case. And I want to say this was like maybe 2006 or 2016. Anyway, and they thought, oh, well, let's do a local interest. So they went to and found like the mother of Ernesto Miranda. And they said, oh, on the occasion of the Miranda case, you must be so proud of your son. This famous Miranda case, you know, your Miranda Rights. You must be so proud of your son. And I thought, that's an unusual thing to say because, yes, the Miranda case is a very important case. Did he do anything in particular to warrant adulation and praise and all that kind of stuff? Not particularly. He got arrested. And then while in custody, you can write this down, while in custody, he provided information. I mean, he basically, I want to say he confessed, but he provided information to the police. Okay? That information was not necessarily something that helped his particular case. Okay? It helped the police. Is that good police work? For the police to gather information from a person who is arrested? Is that good police work, to gather information from them? Yes, it's good police work to do that. Yeah, it is good police work to gather relevant information. Okay? But here's the deal. Ernesto Miranda's attorney looked at the case and was like, thinking, I think maybe you probably should have not have spoken when you did, because that didn't necessarily help the case, or the defense case. Because who has an obligation to prove beyond a reasonable doubt that the defendant is guilty as charged? Okay, you got the plaintiff, which is the state, or you got the defendant, which is the criminal defendant. Who has the burden of proof? The state does, yeah, the prosecution does. Okay? So that's good. Woo. So the police officers got to do their job, the prosecutors got to do their job. If they don't have proof beyond a reasonable doubt, the defendant is not guilty. Okay. Guilty, not guilty, you know, whatever. So, all right. So, here you go. Here's the deal. Sit down. Sit. Don't touchy. Those are hands off my Matrushka dolls. Okay? They will haunt you. Yes, they will come into your dreams and send you into gulag. Anyway, so, we will put you inside of one. You will be a little nesting doll. Yes, it really, okay. All right. You'll be like, I can't get out. All right, so here we go. Ernesto Miranda's attorney looked at the situation and was like, well, this is not really fair, because in fairness, what the police officer could have done was, look, we arrest you on this charge, okay? And you have to have enough evidence to arrest somebody. You certainly have enough evidence to bring the case. Okay, then they plead not guilty, and then they have the trial and so forth. What the lawyer insisted, which was not a requirement, was that the police officer should, like, inform the defendant of certain things. Because when you're arrested, it's not much fun. And there's a lot of stress involved. And you might want to get away from the stress. The stress might be like, I just want to be out of trouble. I want to be free from all of this. And the police officer looks at you with such hopeful eyes and words. and says, well, this would be so helpful for you in this situation to just tell me what happened. Okay? Yeah. Now, is there something in the Constitution that requires criminal defendants, anybody who's arrested even before you get to a criminal defendant, you get a full charge against you, is there something in the Constitution that requires you to answer questions from the government? In fact, is there anything that says opposite of that? It does. What? Which part? Which part? Which part? Which part? Which amendment? I love that. I'm holding my hand out. They're like, first? I love that. The first. Shh. That would make sense. Shh. The shh amendment. The what? Fifth Amendment. Take the fifth. Did you? Okay. Well, I didn't hear you. It's okay. All right. So write that down. The Fifth Amendment says you have the right to remain silent. But is there a requirement that you have to be informed about it? How many of you guys are not informed about the Fifth Amendment? No. None of you, because you've all been listening. You've been silent while I have been teaching, and you have learned this. Even though some of you guys, the first? No, the fifth. Whatever, it doesn't matter whether you know the number. Okay? Shh. So, here's the deal. The attorney for Miranda is like, hey, talking to the judges and ultimately appealing up to the Supreme Court. The Supreme Court accepted the case, and the Supreme Court ruled in favor of Miranda. Yes. This is why we have Miranda rights. Write this down. The Supreme Court said, from here on out, shh, because a person in a particular situation being arrested is undergoing a lot of stress and is very vulnerable, it is the responsibility of the government, that is the police officer, to inform that person in custody about certain rights. Not everything. They don't have to sit down and get a condensed version of my unit. You don't have to be informed about all of your rights under the ADA, or your right to vote, or your right to, free speech or whatever. But there's certain ones you have to. And the Supreme Court said these in particular are important in the arrest situation. First, write it down. The police have to inform them of their right to remain silent in the Fifth Amendment. Okay, you don't have to refer to the Fifth Amendment, but you say you have a right to remain silent and elaborate on that. Anything you say could be used against you in a court of law. Okay? Kurt, what other kind of right do you suppose would be important for somebody who is potentially facing criminal punishment to know and have kind of in their head as they're under arrest and kind of contemplating like their next move? Okay, we got that one. So the right to remain silent against self-incrimination. Self-incrimination is kind of a fancy term, so they basically tell the police officers, tell them they have a right to remain silent, and then elaborate anything you say can be used against you. Oh, I get it. So I should maybe not say everything right now. What would be something else, do you think, that maybe that person would really benefit in knowing for a fact? Yes, write it down. You have the right to have an attorney, the right to have counsel. And that is in which amendment? Sixth Amendment. Sixth Amendment's got a bunch of different rights in there, and that's one of them in there. Okay?
Somebody argued that they didn't understand the rights, or they're really...
I'm going to get to that in just a moment. I'm going to get to that. Okay? I'm going to get to that because you're going to have, there's all these little wrinkles. Let's fill out the rest of the so-called Miranda rights. All right? So we got the right, you got the right to an attorney. Well, the defendant's sitting there thinking, the person who's arrested is like, attorney. Wow, if I could afford an attorney, that would be nice. So I can't afford an attorney, so I guess I don't have a right to an attorney. Where the heck does that come from? You mean you're going to get a public defender? Yeah. Who says you got a right to have an attorney paid for by the... Is that in the Sixth Amendment? You're saying the Sixth Amendment. According to who? Really? As interpreted by who?
Me.
The Supreme Court. In what case? In what case, Chris, Does the Supreme Court say prior to 1966, and not much prior to 1966, come on, you go, you get on over there, you get...
Is it the Gideon?
Yes, it's the Gideon case. Very good. Okay? So that's the other part of it. Okay? So Miranda rights. Anybody who's spent much time watching television and so forth, law enforcement things, knows that when a person is arrested, because you might not have this personal experience, but if you watch enough television, you have the right to remain silent. Anything you say can be used against you in court of law. Boom! You have a right to an attorney. If you cannot afford an attorney, one will be appointed for you in the court. 3 rights. Do you got that? That's the Miranda rights. Now let's get to the particularities of this. After this, because this is very important, if the police don't issue the Miranda rights, let's get to the kicker here, because I've actually got it in your notes. It's already spelled out very clearly. It's a case that I covered earlier. If the police do not, if the police do not give you the Miranda rights, and you're sitting there and you're thinking, oh, I got arrested, and that police officer, 1 out of 100 police officers in any given situation, I would say it's even less, didn't read the Miranda rights. Wow, your rights have been violated. But what consequence? What do you have to actually do for there to be possibly a consequence?
You have to, essentially not engage in any of those rights.
So let's say here you are, you're somebody, you're actually in the car, you've been arrested, and you're completely clueless. You're one of those very few people, I would say, in the United States of America that doesn't know that you have a right to remain silent, that doesn't know their Miranda rights. And you're in the back of the police cruiser, and you confess. You got it? Write that down. If the person confesses, if they say something, and they haven't been given the Miranda rights, what happens to that statement, that confession? It gets thrown out of court, according to you. No, we can't cite you. You need to know what is the name of the case that excludes evidence that has been obtained in violation of a constitutional right. Map versus Ohio. Very good. Map versus Ohio. You got that? Does that make sense? Okay. Now, let's go to the practicalities of it. The police officers sometimes arrest people who are not really fully having a grasp of everything that's going on. So they want to be able to prove that they did it by the books. Should the police officer say the Miranda rights? Should they also record them saying the Miranda rights? Yes. And here's another thing they do. So you got that? Here's another thing they do. In the police station where they're booked and so forth, they would also give a printed version of the Miranda rights and have them sign it. So later on, if it ever comes up as a question, did that person not get the Miranda rights? You got a recording and you got a written thing, which may be even videotaped. Good grief. Talk about all those different tech things. So if the person's like, well, I was well over the legal limit in alcoholic consumption, right? Does that invalidate it necessarily?
I think so, because they essentially may not, if they were blackout drunk, they may get just...
They're blackout drunk, are they going to be confessing?
Well,
They might be out. And actually, Owen, as a good police practice then,
they may not remember their rights being recognized.
it doesn't matter if they remember or not. If they have their rights and so forth, that's going to be the key thing. But as far as good police practice, should they do it when they've sobered up some?
Yes.
Probably another good idea to do it while they've sobered up. Okay? Especially if they're anticipating that the person is going to confess. Okay? We want to make sure, so if you're going to confess and, be helpful to the police investigation, we want to make sure that you are Mirandized. Literally, it's a verb. You're Mirandized. Why is that a verb? Because that's his last name. That's his last name. And why is his last? Because that was the guy that was the person in the case where the Supreme Court first announced that you have to be informed of certain things. Got that? Okay, now, just on the side, just so that you understand this, are there other important rights? Is it important for you to know that you have the right to cross-examine and confront a defendant? Yes. Good. So what if, later on, you're in court, And you're like, oh, what the heck? I plead guilty. Do you suppose the judge is just going to let you plead guilty right there without making sure that you're informed of all of the rights that you're just like pushing aside, that you're waiving? Put this in your notes as well. Are you ready? This is a little bit further along. This isn't like at the time of the arrest. Okay, this is going to be like at the initial arraignment when the person has an opportunity to plead guilty or not guilty. You understand that? Like that day or the next day. You got the opportunity to plead guilty or not guilty. And you're going, oh, just, I plead guilty. Well, before the judge is going to take that guilty plea and maybe even issue a sentence right then, they're going to make sure that you're waiving all your rights. You're aware of the right to have an attorney, have cross-examination, subpoena your own witnesses. I haven't gotten to that part. To have all these different, very important trial components. And they're going to make sure they get it all on the record. Do you remember the story we told about a certain Idaho senator who was charged with a crime in the state of Minnesota? Do you remember that one? The toe-tapping one? Oh, good. You guys have forgotten. You remember that one? The wide stand? Yeah. The solicitation of sex in a public restroom in an airport in Minneapolis? Okay. What? You're like, oh, you don't remember that one? So the United States Senator was like, oh, I don't want to go through a trial on that because that's going to be public and everyone will find out. Well, guess what? He pled guilty. He waived all of those rights. And since a guilty verdict is just as public, people found out, it became well known in Idaho, and he's like, wait a minute, I want to have a trial. It's too late at that point. The judge is like, you've waived all your rights, you've pled guilty, you were informed of those rights, so sorry, too bad. Do you understand that? Okay, now, let's go through some particularities that are kind of interesting as far as like, what would happen if, okay, I need a perp. Another perp. Okay, we got a perp right there. Okay? You're a perp, and I'm the police officer. Okay? And let's just say, for example, you're charged with, I don't know, a gun crime, murder. Okay? And by the time we arrest you on the charge of murder, you have dispensed with the gun. The gun is nowhere in sight, as far as we know. But you know where the gun is. Yeah, you do, because you're in this situation. I'm doing the facts. You know where the gun is. You knew where you got rid of it. Okay? All right, so here we go. Listen very carefully. I am a clueless police officer, and I arrest him. Aha! And I forget to read him his Miranda Rights. So I'm sitting there going, ha-ha, I got the murder. I'm doing so good. And I go back to the police station. Meanwhile, he's like, blah, 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 blah. He's just spouting off everything. And I'm going, that's great. I've got all that recorded. I can use that against you in the trial. But, Anna, he says, I put the gun in a deep hole in a bag in a abandoned place that nobody ever will find and so forth. But that's where I put the gun. I'm like, good. Can we use that against him? Can we dig up the gun at that location, take the gun, and use it, fingerprint it, and see that that was the gun, and do the ballistics test, and see that that was the gun that was used by the criminal to kill the victim? So what? Says who? No, not the Miranda Rights, not quite. What case says that evidence will be excluded if it's obtained in violation? Now, the Miranda Rights says that I needed to inform him of his right to remain silent, and he went ahead and confessed. So what's the kicker part on that one? I knew on the map, hint, hint, where to find the evidence. What was the name of the case? The exclusionary rule comes from what case? Everyone said together? Map versus Ohio. Yeah, so you put those two cases together, and it's excluded. Got that? It's excluded. However, there is an exception. Yes. Yes, there is an exception to the exclusionary rule. Oh, trust me, when police officers and prosecutors and so forth are going through, they're like, well, not this way, but then this, and then maybe that, but not that, and then this, and maybe you can get it in. Woohoo! We can get it in still. Woof! Yes. You put the person in the trunk of your car. Okay, what I know. Let me finish out this one. All right, you ready? Write this down. This is called the inevitable discovery exception. It's in your handout. The inevitable discovery exception. And it kind of sounds like what it is. So Anna, what if instead of saying in a deep hole in a bag where we're never going to find it unless, except for the fact that he told us where it was, let's say that he threw the gun away in the middle of Boise Town Square Mall. There's the smoking gun with his fingerprints all over it in the middle of Boise Town Square Mall. And as it turns out, take your pick. We either go retrieve it because he told us where it was, or somebody else comes along and sees it and goes, oh, look, there's a gun in the middle of Boise Town Square Mall, and maybe we should report this to the authorities, and then the authorities pick it up and retrieve it. Am I going to be able to use that evidence against him? Why? Is it really him that provided us the way to find it? Were they likely to see it? Yeah. Inevitably, would the police have found it? Yeah. So it's not really tainted, even though one track to find out where it was is spoiled because I didn't give him his Miranda rights. Does that make sense? That somebody would have come along at some point in time and they would have found it with the fingerprints all over it. So that's like a fail-safe because the courts don't want to be like, you messed up. They want justice. They want his rights to be observed, but they don't want it to just be some little stupid, oh, well, you didn't follow the book exactly. You made one little error here, so all of your really good evidence is thrown out. Because that evidence could have been found multiple ways. I would be careful about doing that. That's an interesting point. Think about that. Gabe suggests that in that rare case where the police officer doesn't read you your Miranda rights and you're sitting back and you're like, you're just too clever. You are too clever for yourself and the entire planet. You're back in the police cruiser and you're thinking, I'm just going to go ahead and confess to everything because all of that now has been spoiled. Do you think that the prosecution and other law enforcement types are going to try and figure out other ways to get it into the court to be used against you? Heck yeah, they're going to be trying all kinds of different things, including the inevitable discovery and similar types of exceptions like that. Okay? Yeah. So what?
Someone else's private property.
If somebody inevitably on that private property were to see it, okay, so Boise Town Square Mall is private property, but let's just say they threw it on the front of somebody's lawn.
Right, but not easily visible?
That's the key thing. It's the not easily visible. Is it not easily visible or not? Because if it's not easily visible, the only way we're going to find it is that confession.
But then can they go get it even though it's on someone else's private property? Oh, no. They can get a warrant on that.
They can try and get the warrant, but of course if the warrant is obtained on the basis of information they're not supposed to have, then that warrant is soiled, and then it's no good. It's a tough thing. Just write this down. Police have got to go by the book. They got to go by the book. When making an arrest, you got to go by the book. When taking somebody into custody, you can't put them in a worse situation than they are already. You can't cut off their breathing. You got to go by the book. Otherwise, you could not only lose the case, but you could be held personally responsible for what happens there. Yes? What about Scooby-Doo? Ruh-roh, they are not government employees. They're not the government. They're private investigators. No. And they would have gotten away with it too. For you kids, yeah. Depends on how you do. You have to, basically, you can't use stuff in court if it is from this tree, the fruit of the poison tree. Do you understand that? So in other words, if the route to get there involves a violation of constitutional rights, and that's the only route, you can't use that. Okay? That's why the police have to go by the book. And they're very, very meticulous about that. Okay? And they know what they've got, because they've got a situation where, particularly, they've got 3 people who were all arrested at the scene. We're not really quite sure who the hench leader is, but maybe we think it's Drake. Okay, that was fast. Boom, boom, boom. Did you feel that? That bus went over you in a very, very solid manner. So he's on the witness protection program, and he's being relocated. Yeah. I wouldn't go there. Yeah. Okay. All right. We about wrapped up on this one. Caden, last question.
Yes, the Scooby-Doo, they're usually hired by somebody who owns the property.
They're not like always. Sometimes they're just like on vacation. They're like,
Yeah,
hey,
but
go check this out.
They're nosy.
That's magic, and then
They're nosy. They just want to get involved in it. They're just nosy. Yeah. It's like the lady, what was it, Murder, She Wrote, I forget the Angela Lansbury thing. It's like the lady shows up in some community, and it's like, oh, everyone's so happy to see her, but you know somebody's going to be dead within the first 5 minutes, and then she'll have it solved within the hour, not including commercials. Okay? So, there we go. All right, let's continue on with criminal justice rights, the right to be right to be informed about the nature and cause of pending charges. This is kind of a combination thing. It's like writ of habeas corpus. They can't put you in jail without a good cause. Okay? They have to have a charge. It's also in the Sixth Amendment. They have to have a charge. Now, let me just throw this out to you. Can they detain you without a charge?
24 hours.
Wow. Is it possible for the police? Wow, he knows a little bit too much. Is it? Have I told you the story about how I was detained one time? Oh my gosh, you're so accusatory. Because the police are doing their investigative work, and I was detained, you all of a sudden assume that I did something guilty. I did not. I was driving my car. And I was stopped. And the police did a lawful detention. Did I tell you this story? I did. I think I did tell you this story. Yes. So I was driving past. So some of you guys were here for this. Maybe some of you guys saw it on the video, what I did earlier. But this is one I always bring up at this time. This is a legal investigative detention. You can write that down. It's a quick detention. Okay? And if it's a quick detention, the police do not have to inform you of your Miranda rights. They don't have to tell you have the right to remain silent and so forth. They're just saying,
Come with us downtown.
no, not quite. A brief investigative detention. Okay? So they're like looking at things and they're like, I just want to, can you stay here I got a couple of questions and so forth for you. I mean, can you invoke the Fifth Amendment, right to remain silent? Yeah. Sure you can. Which will raise a level of suspicion perhaps on their part. I don't know. Anyway. So here, you guys remember the story. I was driving past my old high school in Arlington, Virginia. Okay, I'd been to a play with my mom. And who else was in the car? I think my wife was in the car too. I think there was a bunch of us that were back there on that trip. So we went past the high school. And there was a flame. It was a flaming trash can. There was a trash can on fire right next to the high school that I went to. And I pulled over. And I took out the squeegee from the back of my mom's car. And I went over and I kicked the trash can over. And I took the squeegee because that was all I had. You have to just kick it once. And then, and it put the fire out. Woohoo! Have you ever been to a gas station? What do you use to clean the bugs off the windshield? Squeegee. Seriously? So, and the squeegee got the brunt of it because it had like a plastic component and it was all kind of melted. That squeegee was no good. But the fire was out. I was the hero. And I'm driving home and meow, 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 meow. Police officer pulls me over. The reason we're pulling you over is because there was somebody that reported your car in the location of where there was a fire. And we have some questions for you. I'm like, well, let me tell you. I saw the fire too, and I put it out. And if you'd like to see the squeegee, that is clear evidence of putting the fire out and so forth. Yeah, it was good.
How do you put a fire out with a squeegee? You hit it.
It was a small trash can fire. No, no, that's ridiculous. Yes, you provide the squeegee and the trash can and your front yard, and then we'll do the demonstration. Does that make sense? So is that a lawful detention? Yes. Okay. Okay. See, squeegee. Because it squeegees. It's sort of like a sound that it makes when it's like, you know, rubbing across the... I could have used my shoe, but then my... Anyway, I don't want to... That would not have done. Okay, so brief investigative detentions are okay. They do not require the person to be Mirandized. Do you understand that verb now? Max, what does it mean to be Mirandized? Which ones? And with respect to the lawyer, and one will be provided for you if you couldn't afford it. Yes. Oh my gosh, don't you know that? Don't you guys watch police shows anymore? People used to know that. I mean, that was the one thing you'd be certain of. Students would know the Miranda Rights. Okay, anyway. All right, so this one is fairly self-explanatory. If you can't bring a case, you can't hold him in custody. With two exceptions. Historically, Robbie, what was one historic exception where the government was like, okay, we're taking you all into custody. We're not charging you with any crimes, but you can't go anywhere. Yes, World War II. Who? Japanese Americans. Okay, that was another one. This was a little tougher. Do you remember the other case in U.S. history? You remember?
It was Abraham Lincoln and the Southerners.
The Southerners? Who were not in Deep South, but they were Southern sympathizers in some of the border states. The Southerners. So they weren't quite Southerners. They were more like Southerners. Yeah. They live in Maryland and Kentucky and, yeah, South, but not Southern. Anyway, that is kind of weird because South is the South. And anyway, whatever. All right, you guys ready for the next one? Here we go. Speedy trial right. Here we go. Write this down. Speedy trial right. You have a right to a speedy trial. It's pretty self-explanatory. Okay? In other words, the government can't just drag it on and on and on and on. If the government has enough evidence to bring a charge against you, the clock starts running when? As soon as you give a plea. For the speedy trial right, as soon as you have a plea. So, for example, if they're like, we got charges against you, and you fly to Russia or someplace like that, right? You know anybody who's been charged with crimes in the United States of America that has fled to Russia?
I did the other way around.
You did the other way around, okay. Actually, no, Snowden, Edward Snowden, right? I'm pretty sure he's facing charges. Anyway, he's in Russia. But here's the deal, write this down. He hasn't pled guilty to anything or not guilty. So the clock doesn't start running. As soon as they plead, particularly not guilty, because you're asking for a trial, not guilty, I'll have a trial, as opposed to let's set it aside for another date for sentencing, because then the judge only looks at how much time am I going to give you, considerations like that. So how much time does the government have to make sure that the trial takes place after you plead not guilty? 1 year. Write that down. 1 year. 1 year. Okay? I mean, it actually is pretty long. The guy who, Officer Chavon, involved in the George Floyd case. When was his trial held? Within a year? I just told you, today is the anniversary of George Floyd's arrest and death. Okay, and that trial was held within 1 year. And I think they wrapped it up just about a month or so ago, wasn't it? Okay, question. Yes. So, 1 year. Now, here's the deal. Write this down. If the defendant, like maybe a month out from the trial, okay, is like, oh, we need some more time, and requests the judge to delay the trial, for like obtaining witnesses or some other kind of thing like that, whatever. And the prosecution's like, okay, so you want to delay the trial? What if that delay will push it beyond the 1 year time? Is that going to throw the case out? No, because depends on who's asking for the delay. If the defendant does it, they can waive their Sixth Amendment right to a speedy trial, or at least sort of waive it. It's not like, oh, they waive it once and then the thing can be kicked out in 3 or 4 or 5 years. Delayed. If the state needs the delay, the defense can be like, no. If you want to do anything on this thing, if you can't get it done within 1 year, after we pled not guilty, it's it. Total dismissal if that kicks over after a year. Do you understand that? Okay. It's slightly different. In your notes, I also put down statute of limitations. Let me elaborate on this one. Statute of limitations. This is another thing that sort of like is a tick, 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 tick. And this is important because statute of limitations, the charge has to be brought within a certain period of time. If it's a minor charge, like some traffic offense, 1 year is the typical amount. Statute of limitations. The police officer can't come to your house 2 years after seeing you speed on the freeway and go, we're going to give you that ticket now. That would be kind of harsh, wouldn't it? Statute of limitations. There is a limit. Statute. It says it in the handout. I don't know. Don't be rude. Here we go. Statute of limitations. You see that? Okay. Statute of limitations. So if it's a murder charge, what do you think, Gabe? Yes? Yes. Okay. Okay. Before you go, what do you suppose the statute of limitations is on a murder case? How long does the state have to bring murder charges against somebody from the date that the murder particularly occurred? No, not a year. Unlimited. Most states are going to be unlimited. Yeah. The basic rule is this. The more serious the charge, the longer the statute of limitations is. I don't know. There's 50 states, and I don't know the law in every state. So I'm making a generalization here. The general trend, stop it. The general trend is that the more serious the charge, the longer the statute of limitations. Here's one that has been changing. Write this down. Over the years, they've extended the statute of limitations on child sexual molestation cases. And that's a controversial one. Okay? As in, if you have somebody who is 25 years old who says, I was violated by the law, by this person, when I was age 5. That's a serious charge, isn't it? Now, if that actually did occur, do you want the perpetrator to actually be punished? Yeah, because a lot of stuff like that, people get away with it. Do you have any concerns that that's pretty long ago and the memories might not be quite sufficient to support a conviction after a trial in court? If somebody is charged with that, are there any negative consequences for the person who's charged with it, even if they're not found guilty? Sure, yeah. I mean, having a charge like that is pretty... You're like, have you ever been found guilty on, like, child sexual molestation? And you're like, nope, not been found guilty. They're like, yeah, I think we're going to go to the next interview person. Do you understand that? That's why I'm saying this is a very controversial area because, one, the government wants to do something about this. And they do understand the idea of repressed memories and so forth. But at the same time, they're going to ask for lots of corroborating evidence and things that will help support it, because otherwise you're dealing with issues of like, conflated memories and things that aren't quite there. But put this down. Most states have been actually increasing the statute of limitations on those cases, because sometimes you just can't bring them within, 5 years or 10 years or maybe even 15 years of the date that it occurred. So that's why they're kicking those out to a later date. Yeah. Yes. Okay. So, that makes sense? Statute of limitations? Speedy trial? All right. Good. Okay, let's continue on. Because otherwise, as it says right there, you get out of jail.
You don't go into jail.
Well, yeah, I mean, it's like the case is gone. It's over. Okay, here we go. Eighth Amendment. There's two parts of the Eighth Amendment. We're going to be doing cruel and unusual punishment next, but right now we're going to start with excessive bail. And this has actually been talked about quite a bit over the last year as far as bail. Let's understand how this works. You're charged with a crime. Okay, they arrest you. They book you in jail. Okay, are they going to do the trial right then? No, of course not. I mean, they might not do the trial until like sometime within the outside of that 1 year period. Meanwhile, what are you doing? Well, it depends. You might be home or you might be in jail. If you're home, you're awaiting those times when you have to show up in court, particularly for the trial. If you're found guilty, then for the sentencing hearing. Got it? So, what's this whole concept of bail? Write this down. This is the opportunity for the government to say, we want to make sure you're in court on those very important days. We don't want you to disappear, to go wandering away and not show up in court. Do you understand? So we're going to make you make a promise. And to back up that promise, we're going to make you pay money. You understand that? That's how bail works. It's a promise with money, if the judge will allow it. The judge says, all right, we're going to let you go, but you have to promise to come back in court, and you're going to have to put down $1,000, or $2,000, or $10,000, or $100,000.
That seems a little excessive.
Now here's the question. What is excessive? All right? Here's the deal. You can write this down. For a lot of different offenses, there's like a standard bail. Like, I don't know what it is for like a DUI, but I don't want to say like $1,000 or $2,000 or so. Standard. But if the person actually has multiple DUIs, is that going to potentially raise the amount of bail? Write that down. Some things will justify increasing the amount of bail. Basically along these kind of categories. You ready? Because I used to do this all the time once I was a deputy prosecutor. I was once upon a time, yeah. So I would come in, and here's the deal. And typically it was kind of like this person had just been arrested, the bail amount is set here, okay, and they can't make bail, so they've got a bail hearing. And so sometimes, they'd be asking the judge, just let me go on my own recognizance. Like, what the heck is that? Release on recognizance, ROR? Just let me go on my promise that I'll be back here, Your Honor, on the next time that I'm supposed to be here. I don't want to spend any more time in jail because I can't afford to make bail. Well, sometimes you look at that situation, ROR, release on recognizance. Basically your own promise that you're going to, be cool. All right? But sometimes, when I would go into those hearings, the police department would provide, or our prosecutor's office, I think, did this also, they would provide a rap sheet. And I might actually argue to the judge, we argue that bail amount should be higher. On what grounds could you argue something should be higher, or conversely, argue that it should be lower? Here are the grounds. You ready? 1, is the person a flight risk? Write that down. This is one of the considerations that the judge is looking at. Are they a flight risk? Are they likely to not show up in court again? Do you know one of the reasons why O.J. Simpson was not given any bail, as in they didn't set a bail amount for him. They basically said, you're not going to get bail. You're going to stay in jail. Was he a flight risk? Yeah, he was like driving his Ford Bronco rather than pulling over immediately when the police came to arrest him on the charges. Okay, so flight risk. What kinds of things will weigh in? If you own a home in the area, are you more or less likely to be a flight risk? Very good. If you just showed up in the area 5 days ago, are you more or less likely to be a flight risk? More likely, okay? So those kinds of considerations. You ready? Next. The severity of the crime. That's an easy one. The more severe it is, the higher or lower the bail? The higher, because potentially you're going to be facing a higher penalty when it's all said and done. If you're facing a serious prison charge, or a charge that you ultimately can go to prison for, that's going to rack it up way high. Or in O.J. Simpson's case, they didn't give him a bail opportunity. Yeah? Yeah, you basically, yeah. And here's the thing. If you don't show up, the judge will issue a warrant for your arrest and set a certain amount, and then, yeah. I mean, that's what it is. Here's another thing they look at. What is your track record of showing up to court when you're supposed to? This is where it really comes in, because I can remember making arguments to the judge saying, Your Honor, this person has failed to appear in court on 5 occasions. Is that going to help raise the bail or lower it? It's going to raise the bail. In other words, they don't show a good tendency of actually showing up when they're supposed to. Okay, does that make sense? Yeah. Sure. Serious charge. Oh, flight risk, another component. Uh-huh. Yeah, I think you're talking about like Velo and her husband or whatever. Yeah, over in eastern Idaho. Yeah. Here's another component they look at. Likelihood of success for the prosecution. Now, if you're going to bring the charge, you have to have enough evidence to actually like show that you can actually go to trial. But if you've got a lot of really good evidence, argue it to the judge. Your Honor, we have scads and scads of evidence and so forth, and yeah, there's going to be a guilty verdict on this ultimately.
So I'm kind of thinking, right? Like, say I'm fresh out of high school and I have like no money, and like one of these is set against me, right? And so the government's like $1 million. I'm like, wow, that sucks. But what if there's someone who's like, say you're Elon Musk, you have all this money, you can do whatever you want, and he gets the same thing. Would they also put it?
This is an interesting thing. Actually, let's look at that. The person's personal wealth. O.J. Simpson, at that particular time that he was arrested, had a lot of personal wealth. So a $1 million bond might not have really kept him grounded. So ironically, the wealthier a person is, given everything else being the same, they might have the bail even higher. Because $1 million is real money for you and I. You would not be bailing out on $1 million. But somebody else could. And $1 million is chump change for some people on this planet. They could throw down the $1 million. It's kind of remind me of like traffic tickets in Finland. You know, you and I would pay, I don't know what the speeding ticket is now, $100 or something like that. In Finland, they base it on your income. And there really was some wealthy person who ended up paying like a speeding charge of, I kid you not, it was in the hundreds of thousands of dollars, as a way of trying to deter that sort of behavior in the future. Yes? We're going to get to the bonding thing in just a sec. Okay? But that is something that is looked at. Okay, so you ready? Here's another one. Write this down as well. Danger to others right now. So in other words, if, for example, if the person has exhibited a lot of dangerous behavior and just cannot, you're like arguing to the judge, you cannot let this person out. They are a continual danger. They've threatened this person, they've threatened that person. Or, I can remember this at one time, we had somebody who had like multiple DUIs within a very short period of time. We're like, Your Honor, we've got 3 pending DUI cases. And I remember in one particular case, this person did not get out on bail because the amount was set really high, and they were basically sitting in jail drying out. which was a good thing. It was forced alcohol detox, at least as far as that was concerned. Okay, so those are some of the kind of things that will be considered. Got that? Some people are like, oh my gosh, it hurts, it's not good, and so forth and so on. And some arguments have been made in recent history to just get rid of bail. Get rid of bail altogether. Don't make anyone promise that they're going to be showing up in court. So if you don't have to make a promise to come back into court, are you going to be coming back into court? Oh, did I tell you what happens if you break the promise after putting $1,000 or $2,000 bail money down? You don't get it back. You can write that down. You don't get it back. If you do fulfill the promise, do you get that money back? Yes, regardless of whether you're found guilty or not guilty. Does that make sense? Now, let's get into the business of bail bondsmen. Okay? I don't think I've got that. No. Bail bondsmen. These are businessmen, and they've got their businesses typically set up near the jail, near the county courthouse. Because there's people sitting in jail going, oh my gosh, my bail is $2,000. I don't got that kind of cash. I mean, I've got a car, I've got a house, I've got property. What's a bail bondsman to do? Here's what they do. You ready? You call up a bail bondsman, and they will say, all right, you give me, I forget what the amount is, but like 10%. You give me that money, and I'll cover the bond. I'll cover your bail. All right? So you'll get out of jail. Now, you're not going to get that money back from me because the bail bondsman is basically making a promise to the court on your behalf that you're going to show up in court. Anybody interested in going into that form of business? I need somebody to go into that form of business to help me out. Okay. All right, you're in business. Max, this is bonds. I love that. Max bail bonds. We'll get out. We'll make... Anyway. So I'm trying to think of a clever statement. Max bonds. All right, so what if you bailed out the defendant right here? Okay? Bond was set at $10,000. Bail was set at $10,000. You put the $10,000 to the court. And you take from him like, I don't know, 10, 15%. You're not going to get the money back. But you have to show in court. What are you going to do if he doesn't show up in the court? Take a loss. I love that. He goes, take a loss, pal. You just lost your money. You promised the court he was going to show up in court, and he's gone. What are you going to do? He's going to hire him as a bounty hunter and go find him and take him into custody and bring him back and so forth. I mean, it's an interesting line of work, and you need to stay ahead of it because sometimes you lose that. Are you going to be, here's the deal. What are you going to take as collateral? What are you going to take as a better form of collateral? A car or a house? A house, because houses generally don't get on wheels and drive to the next state or some other location. Whereas the car, he could get in the car and drive away and change, anyway, all kinds of problems, yes. Could you what? A pet. No, what kind of pet? How valuable is your pet? A family? No, you cannot bond a family member. Oh my gosh! I volunteer as tribute, says, yeah. Oh my gosh, stop it, stop it, stop it. So, yes, quick. Yep. All right, questions about bail bonds, the situation there? Okay? Seem fair? So argument up, argument down, you need to come into court, make sure you're there. What is your right? It can't be excessive, and that all depends on the amount. The judges try and flex it one way or another. Okay? All right, let's go to the next one. Criminal trial jury right. Okay? This was a situation where I basically said if you are facing a criminal trial, ask for a jury. Okay? You get it for felonies. Those are the most serious charges. It says so in the handout. You get it for misdemeanors. You get a trial, a jury trial right for a misdemeanor. And sometimes it's kind of interesting because even though you might not have the right to a public defender, because in that misdemeanor case, the judge might say, oh, if you're found guilty, you're not going to jail. You're just going to have to pay a fine. But you still plead not guilty, and you'd represent yourself, and they bring in people from the community. for that jury trial. Who comes in from the community? Are you guys going to potentially be coming in from the community to serve on a jury? When you're 18. Which lists does the county